SJC-12441, Homeowners Rehab, Inc., et al., v. Related Corporate 5, Special Limited Partner, LP, and others. Thanks, Frank.
Mr. McKenna, good morning.
Good morning, Mr. Chief Justice. May it please the court, Dennis McKenna, representing the appellant, Limited Partners. In my argument today, I intend to address 4 issues. The central issue to be decided is whether the HRI agreement, known in the documents as the option agreement, provides HRI with a self-triggering right of first refusal, as ruled by the Superior Court. We say no, it did not. The right of first refusal granted HRI was triggered only if the partnership received a bona fide offer and was willing to sell, neither of which were present here. Secondly, does the Superior Court ruling give meaning to all of the terms of the agreements, including the option portion of the HRI agreement? We say, no, it did not, and the Superior Court, in its ruling, agreed that its ruling rendered the option meaningless. Thirdly, did Congress, when enacting Section 42I-7 of the IRS Code, seek to create a new species of rights of first refusal, as the Superior Court believed, no longer requiring a bona fide offer and not requiring a willingness to sell? We say no, it did not. Section 42I-7 does not alter the common law right of first refusal or attempt to redefine.
Well, everything is tax-driven here, right? I mean, don't you all agree that the whole concept you're dealing with is driven by the tax benefits, right?
These particular types of projects are enabled because of the tax policy.
Right. And the structuring of the offer and the first refusal also is triggered by the tax laws, right? They're not out of nowhere. All of this, it's all designed, to meet the federal tax definitions, right?
May I parse through your
question?
question?
No, go ahead. I don't mean to. It's not rhetorical. It's a question.
So the right of first refusal is because, and it gets to the essential nature of what a right of first refusal is as opposed to an option. So under tax policy, and backing up, so in 1986, Congress decided we no longer want to have tax shelters. And so when this policy was implemented, Congress understood and knew that they could do certain things so long as they weren't creating a tax shelter. A below-market right of first refusal is not a tax shelter. It has economic substance. There's still a true owner. In this case, the property is owned by the people who own it, and there's an expectation of profit. A below-market option does not have those same hallmarks. The
tax law says expressly that this offer of first refusal at this price is permitted, right?
That's absolutely. 42I-7 specifically uses the words rights of first refusal, and the tax credits are not disallowed merely because you provide a below-market right of first refusal. It doesn't redefine what a right of first refusal is. What Congress did not say, Congress considered, as we know from the tax history, the legislative history, Professor Kay, what we know is Congress considered providing a below-market option, but the court didn't do it for 2 different reasons. One, they did not want to divest the owner of the actual rights of ownership, one of which is the right to decide whether to sell. But importantly, it was also because under tax law, a below-market option actually makes the option holder the owner.
You see, you're referring to it as a below-market option. That's characterizing it, right? The option is written into this agreement exactly as the tax law provides for it. How it was implemented here, that's a different story, right?
Well, no. how it was manipulated.
Manipulate, that's your, right. But there's nothing wrong with the way the option was written, was it?
Nothing under 40, so this gets to the 5.4C3 argument that the Superior Court grasped, which said, we want this document interpreted to provide the lowest possible price under Section 42I7.
Right.
And what that means is the lowest possible price if you have a properly exercised right of first refusal or a properly exercised option. The lowest possible price, if there's a right of first refusal, is set forth in 42I7, right within there, and that was given in this case. The lowest possible price, if it's an option, is a market-based price.
I get I see all the differences, but I guess I have, it seems like everyone's structuring this, to make a buck and be consistent with the federal law. And also the option agreement there's an exception to when your clients get a vote, right? If it's, right, go ahead.
So you're referring to 5.4A. So how that works exactly under the limited partnership agreement, and this goes to the limited partners, this goes to the arguments of the appellees that they were given these broad rights, and so they should be able to do virtually anything. But we're not talking about many rights here. We're talking about one, and that is the power to decide to sell. And that right was specifically granted and withheld at the ownership level. The limited partners who put in all the money that made this happen, the 99.98% owner of this project under 5.5B3, one of their consent rights was the ability, the general partner could only sell if the special limited partner gave its consent.
But read the exact provision that says that, right? Because it's a little more complicated, isn't it?
No, so we go, Your Honor, to 5.5B that says the general partner shall not have the authority to do any of the following except with the consent of the special limited partner.
Right,
so then we go
and doesn't that reference the offer? I mean, it references the offer, right?
No.
It references the except according to the option agreement, right?
No, that's 5.4A.
Okay.
So I will get there, Your Honor.
Go ahead.
So
No, this is certainly complicated.
We get back to the fundamental, what is the difference between a right of first refusal and an option? And a right of first refusal is a preemptive right. It's a shield, okay, given to the holder, protecting the holder if the owner wants to sell. The option is a sword in the hands of the option holder that enables the option holder to decide whether it wants to sell regardless of the owner. And that's the Roy case, the centuries of common law in this Commonwealth and across the country and in all the treatises. The option is a high property right. The right of first refusal is a defensive low property right. And that's entirely ignored by the Superior Court. But getting to your question, Your Honor. So we first start with, can the GP sell the property without the consent of the limited partners? And 5.5B4 tells us absolutely cannot. But the Superior Court relied on the exception language in 5.4A that says except per the terms of a sale under the option agreement.
Right.
So, but let's get into your question.
Does it say except under the sale, or is it except pursuant to the option agreement? What's the exact language?
The exact language is except for a sale pursuant to the option agreement.
Right, but the option agreement includes has two provisions, one which allows a sale pursuant to, one which allows the right of first refusal purchase, and one that allows the sale, right?
If properly triggered, there are two mechanisms potentially that HRI could come to own this property. If there's a bona fide offer and a willingness to sell, then they could potentially own it at a below market price under the ROFR. If they decided to buy, they could own it under the option. But getting to your question about the exception language, what is that paragraph? So we already know all sales require our consent. What is this paragraph doing? So may I read the paragraph without the exception language so we can see its purpose? So the purpose of paragraph 4 says, the general partners are hereby authorized to sell the assets of the partnership, provided, however, the terms of any such sale must receive the consent of the SLP. So this isn't talking about the consent to sell, this is the terms. And now I'll read the exception language back in. The general partner is authorized to sell all assets of the partnership, provided, however, that except for a sale pursuant to the option agreement, the terms of any such sale must receive our assent. So, putting this all together, all sales require our consent. The terms of all sales require our consent. The exception is the terms of a sale to HRI do not. And why would that be? Well, that's because the terms of the sale are already included in the HRI agreement. And there's nothing in 5.4, nothing in this document to which the HRI was not a party, nothing in this document alters the common law. This is the limited partnership agreement. Nothing in the limited partnership alters the common law that you still need a willingness to sell, and nothing in the HRI agreement gives the rights to HRI that the Superior Court provided, which is turning the rights under the right of first refusal into a sword, but all they were granted was a shield.
What about the parole evidence that was used or purported to use, and also the lens of the affordable housing structure that the Superior Court judge utilized to, as you say, get around the common law concepts of option and right of first refusal?
So the Superior Court felt, and that was the third argument that we were prepared to make today, the court felt a policy need. Was the court correct in its policy-based conclusion that a ruling in HRI's favor was necessary to protect the project status as affordable housing? Not only do we say no, it was not, there's no real dispute. The Superior Court just got that wrong. This is a contract construction case, unambiguous documents, but the court brought policy into it, which was unnecessary. The use restriction on this property, it's not debated. This property will remain affordable for its remaining useful life. HRI Charitable Trust owns it. They leased it to the limited partnership, subject to the use restrictions that make this property affordable in perpetuity, regardless of who owns it.
And I know we have varying briefs, amicus briefs, that discuss whether or not that's consistent with this public policy, but your main point is just we don't go there. We just look at it as a contract case.
Exactly, and in all those briefs, the request here is build into 42I-7 a policy-based reason to change what the fundamental right of first refusal is. But that's what the parties called.
It's a right of first refusal designed to meet a federal tax problem. It's not a negotiated right of first refusal in an ordinary business deal. It's a right of first refusal. I mean, the signer of the right of first refusal is the same person on both sides, right?
Yes.
Mr. Daly's is negotiating with himself. This is not your typical right of first refusal, right?
So there's been no effort.
I've ever seen somebody sign a contract for both parties.
But that's subject still whether we're going to do the deal. So the limited partners, we're a critical element. We're in affordable housing too, and it should be pointed out on the policy.
No, you're doing good too. You're helping to pay for all this affordable housing. The question is, how much money do you get to make out of this? And you've actually written two fine briefs that we're going to read this week, one today and one Thursday. And you sort of describe what you're getting. The expectation is really to cash out after 15 years. At least on Thursday it is. right?
Not at all.
No, we'll
In
we'll
the
see you
Superior
again on
Court-
Thursday.
Let's stick with today. We have our hands full today.
The Superior Court got that wrong. The Superior Court said, and there's nothing in the documents. First, she ignored the deposition testimony that we submitted of our deponent that said there's an expectation of profit, of an expectation that at the end we would share in any project profits. 9.2A and B both say that exact same thing. So the court got that absolutely wrong. The court was just wrong. The expectation of profits that the court built into the decision was a draft document that wasn't part of.
We've got plenty of at least amicus writing saying the expectation is that you get 15 years of these tax benefits that add up to so many $1 million. You're saying the expectation is that and also the ability to retain this. So I'm not sure the record's going to answer that question,
Well,
is it?
Yes, the record will answer the question because under 9.2A and B, so 9.2A10 talks about cash flow, and at the end, the balance of that cash flow is split between the limited partners and the general partner. And then on a sale, this provision, 9.2B13, shows that the Superior Court, again, was wrong on another issue, that there's no expectation of profit on a sale. 9.2B13 says the balance of any monies left over after the waterfall is all paid is 50% to the limited partners, 50% to the GP. We had an expectation of profit.
I get that, unless there's in your view, a bona fide proposal. But if this were a bona fide proposal, right, none of this would matter, right?
If this were a bona fide proposal and we had a willingness to sell so we retain that right. If we had a willingness to sell.
Your clients have the ability to basically prevent even bona fide offers from kicking in the right of first refusal in.
Your Honor, then that's how the Superior Court characterized it, blocking. But you have to ignore a century of common law.
It's just a question. Do you have that right to prevent the offer of first refusal, even if it was a bona fide? I understand there's some issues about whether this is a bona fide offer, and secondly, whether you need a bona fide offer. But if this were, you still say you have the ability to stop it, right?
Right, but not using those words.
Yeah, use your own words.
So a right of first refusal, a right of first refusal is the shield. So a right of first refusal, the moment you've granted it, is working if it prevents a sale to a third party out from under the holder. That's what this court has said. Roy case, Bortolotti case, Uno case, myriad, including Nickerson v. Fleet in 2010. This court said a ROFR benefits two holders. It protects the owner and its willingness to sell, and it protects the holder. So in this case, it wasn't blocking a sale to the limited partners. It was simply, so the document has worked since 1997. It's provided a disincentive to try to sell, but the HRI agreement is still working because even today, if HRI wants to own this property, it can still own it. And I must point out from the policy, one thing that has been ignored in the amicus filed on behalf of the appellants, public policy is working here. This project got built. The 211 families live there. Their rent isn't going to change. If this court reverses the Superior Court, those families will continue to enjoy the benefits of this project made possible because of us and also the important work of the general partner. But it's not, we did get the tax credits, but they've received millions of dollars to manage the project. They get hundreds of thousands of dollars even during this case to manage the project. But importantly, if this court reverses the Superior Court on the complaint, on the contract claims, the 211 families will still enjoy living there, and it will then be up to HRI whether it exercises its options to become the owner of the property.
I can just ask you one question. When, in your view, does the ROFR kick in? You speak of the willingness to sell.
Yes.
But the ROFR sort of says whether you have, and then you read that to say, oh, that shouldn't have said whether the offer's been accepted. It should say that the offer has been accepted, but that's not what it says.
So the ROFR doesn't say either, Your Honor. So the right of first refusal, and that's what the parties defined it as, is in Section 3. The whether language isn't in Section 3. The whether language is in Section 2 and in Section 4, and that's the notice of disposition and the notice to accept. So all we have suggested is, because there's been an argument that you could, it's a paradox in their argument. They can't sell it without our consent, so they can't dispose of the property, but if you read the word whether to mean whether or not, they could issue a disposition notice. So think about that. The owner doesn't want to sell. We've told the GP we're not going to sell, but over our objections, after manipulating this entire process, the GP issues a notice of intention to dispose of the property where none exists. We've merely suggested, maybe we're not asking the court to rewrite the contract. Our interpretation that you could substitute in the words that simply gives meaning that is consistent with the limited partnership agreement, the HRI agreement, and 100 years of common law. The court need not change the language, though, because where that language is, the whether language, Your Honor, at its core, this is a notice of disposition, and before it's issued, it says the partnership shall not sell the property without it first being issued in writing, given the offer, the HRI, the ability to purchase. It's an intention to sell. It's not whether or not an offer were received, because under that analysis, if the GP is obligated to issue a notice of disposition, even when we got, let's say, $1 offer, if the offer were $1, but the offeror said, I intend to buy it for $1, under the Superior Court's analysis, that's legally enforceable because the person making the offer said, I would buy it at $1. It ignores the bona fide requirement and the willingness to sell.
So let's assume you get a bona fide third-party offer. What must you do to trigger the ROFR, as you call it?
Sure. So under Section 3, we granted HRI the right of first refusal. The GP comes to us. It's a two-party system. The GP must own it, and we are the limited partners. Under 5.5B4, the general partner comes to us and says, do you want to sell? If we give the consent rights that we withheld, then they go back and now they follow Section 2.
Do you want to sell at that price, or do you want to sell pursuant to this offer? That's what I'm trying to get a sense of. Do you want to sell generically? Do you want to explore offers, or must you say, I would be prepared to accept that offer at that price, but I know you have a right of first refusal?
Yes. So it's the accepting of the bona fide offer.
So it's a conditional acceptance of the offer, is what you're saying?
Every time there's a right of first refusal, you can't actually go through the, yes.
So it's a conditional acceptance. I will accept that offer, but the GP has the right of first refusal, and if the GP does not exercise that right, I will accept the offer.
In this case, the GP and the nonprofit are wearing the same hat.
I understand that. I'm putting that aside. But your view is there has to be a conditional acceptance of the offer to trigger the ROFR.
We have to have a willingness to sell. We have to provide our consent to the general partner. So I'm not sure the conditional acceptance of the offer. 5.5B4 says we provide our consent to the sale. So we tell the general partner we would consent to sell under those terms, and then the GP acts on that under the HRI agreement. I'm not sure if it should be characterized as a conditional acceptance. I think better to look at it as you need our consent to sell, but the GP has to be the one to then act on our consent.
Okay, thank you.
Thank you, Your Honors.
Ms. Friedman.
Good morning, Your Honors, Mr. Chief Justice. May it please the Court, my name is Karen Friedman. With my partner, David Lurie, we represent the plaintiffs' appellees, Homeowners Rehab, Inc., and Memorial Drive Housing, Inc. Your Honors, the actions taken by HRI and Memorial Drive in this case it's exactly what these highly sophisticated parties agreed to in their deal 20 years ago. The two main issues here are whether Memorial Drive was allowed to issue the disposition notice without the special limited partner's consent, and whether the offer made by Madison Park was sufficient to trigger the ROFR. Memorial Drive was not obligated to get the SLP consent before issuing the disposition notice, and the offer was sufficient. The Superior Court got it right. First of all, there is nowhere in the partnership agreement or the option agreement that says that Memorial Drive may not issue the disposition notice without special limited partner consent. That term simply isn't there.
What do you, he does rely on a provision. Why don't you address the provision and say why it's inapplicable then?
I'm not, which provision?
Your brother says he does have that right, and I can't pull the provision out now, but it's in 5, it's one of 5's provisions, so.
All right. There's section 5.4A.
Right.
And that's on page 399 of the appendix. What Mr. McKenna is referring to is a provision that discusses when Memorial Drive, it talks about a sale, basically. And what it says is that Memorial Drive is authorized to sell this property under except for certain very limited exceptions. And the one exception to that is the SLP, the special limited partner, has the right to consent or veto the terms of any sale in order for that sale to be binding. In other words, in order for it to be enforceable. That's the provision that I believe you're referring to, or that Mr. McKenna is referring to.
5.4A, right?
5.4A, yes.
Right, but I think what he's saying is, the precise language is, except for a sale pursuant to the option agreement, the terms of any such sale must receive the consent of the SLP. And what he is saying is that the SLP must always consent to the sale, but upon the SLP's consent, the terms need not be agreed to by the SLP because those terms are set by the option agreement.
That's true. Well, I think Mr. McKenna's interpretation makes it a little redundant. I mean, they have agreed to the terms in the ROFR agreement. I'm not sure why they need, in the option agreement, I don't know why they would need to say, yes, and we'll honor those terms. But the point here...
What if they don't want to sell?
What?
What if they don't want to sell?
But that's not what they're allowed to veto here. They're allowed to veto the terms. They don't get the opportunity to decide when or whether to sell. This does not say Memorial Drive may not sell the property unless the SLP consents. It also does not say Memorial Drive may not issue a disposition notice unless the SLP consent. It also doesn't prevent Memorial Drive from soliciting offers, negotiating a sale, or marketing the property. What it says is that at that last moment, where that sale is going to be binding or not, where the sale is going to be consummated, that's when the SLP gets to veto or consent to it.
So what year was the ROFR made here?
1997.
I mean, what year of the project? Year?
Beginning.
In the beginning.
In
just
the beginning.
Before.
So your view is that in year 2 or year 1 of the project, the GP can invite an offer, and then upon the receipt of that offer can say, I will now exercise my ROFR and I will purchase it at the lowest of the 3 prices, which is markedly below what the option price would be.
No, Your Honor, I'm not saying that at all. And there are specific protections within the partnership agreement that would prevent Memorial Drive from doing that.
Okay,
Provisions that protect the SLP or the limited partner's right to receive its tax credits, a provision that indicates that the contribution that the limited partners make will be reduced if the credits aren't received. So there are a number of provisions that would prevent that.
So when can the GP do this? At what year during the course of the agreement? at any time, as long as it protects the tax credits?
Well, generally speaking, the ROFR would, as a practical matter, would kick in after year 15, after the compliance period. And in fact, there is a provision that prevents a sale prior to the compliance period. The ROFR does extend from year 1 all the way through year 19.
Right.
But that provides some protection to HRI and Memorial Drive in case the special limited partner or the limited partners want to get out or they want to sell. That way, if they do want to sell and they're pushing to get out of the partnership, then HRI and Memorial Drive will have an opportunity to get the project back. But they're protected. The limited partner and the SLP are protected by the other provisions in the partnership agreement.
So you're saying we should read those effectively into the ROFR and say, you can do what you choose to do, what you did here, but only after year 15?
Only after year 15, and well, it's hard to predict what might have happened, but between year 1 and 15, I suppose if the limited partners were trying to get out, then they might have the option, they might have the ability to exercise the right of first refusal. But that's not what happened here, Your Honor. We went all the way through the compliance period, they got all of their credits, and now here we are, or here we were in year 16 saying, okay, we want to exercise our ROFR.
Okay,
And that's where it...
But the ROFR doesn't, I mean, I understand your view that so you're saying that in years 1 through 15, you could not do what you did without the SLP saying, I am willing to consent to a sale.
Correct, because there are provisions in the agreement that prevent that.
But at year 15, you can.
Correct.
And that is because then we have to take those other provisions and view those as an implicit limitation on the ROFR.
I don't think Section 5.4A is really an implicit limitation. Well, it's not a limitation on the ROFR, but I don't think it's an implicit limitation on the SLP's powers. It specifically says they've got the right to consent to the terms in order for those terms to be binding. It doesn't say they get to decide when to sell.
Can you flesh that out in simple language for me? Because I'm having trouble now understanding what power the SLP has. They can consent to what? We have two different options, right? We have the option, the lower priced one with the ROFR, and then the option to sell. And when can they use this consent language to interfere with the ROFR?
When can who? The SLP?
Yeah, because I would explain that in some detail, because you've been living with this so long that you understand it, but I at least don't quite get what they can do and what they can't do through that provision yet.
They can't interfere with the ROFR.
Okay, why can't they interfere with the ROFR consistent with that language? Because you're saying that language gives them some powers of consent over something, right? What does it give them power over? What doesn't it give them power over?
It gives them power to decide whether or not to sell to a third party if HRI declines to exercise its ROFR. If an offer comes in and they don't like it, and HRI has indicated that it's not going to exercise its ROFR, then they get the chance to consent or veto to it.
Okay, so that's what your view, when we go back and reread 5.4A, all it does is give them a right over third-party sales. It has no rights whatsoever over the ROFR.
Correct.
Okay, and take now 1 second, go to 5.4A and read me the language and explain how that works, just because at least I'm having trouble following that.
It says, except as may otherwise be expressly provided in Section 4.1 and elsewhere, the general partners, with the approval of each authority, are hereby authorized to sell, lease, exchange, refinance, or otherwise transfer or convey or encumber all or substantially all of the assets of the partnership, provided, however, that except for a sale pursuant to the option agreement, the terms of any such sale, exchange, refinancing, or other transfer, conveyance, or encumbrance.
So the accept language carves out any consent over the the option sale and the ROFR sale.
Correct.
So that's how you read that language?
Correct.
Okay. All right. At least I
Correct.
understand the view.
Now, that, Your Honor, it's consistent with other provisions in these agreements. One is, there simply isn't any prohibition against Memorial Drive doing what it did here, issuing the disposition notice after receiving the offer.
But Section 6 says HRI has the option to purchase, but only after 15 years and only at the restricted market price.
That's the option.
Okay, but so you're saying that we should read this agreement to say, after 15 years, HRI has, under Section 6, the option to purchase it at the restricted market price, and after 15 years, it also has, for all practical purposes, an option to purchase through the ROFR at a lower price,
If an offer is received.
which you're saying it is appropriate for you to conjure or to invite.
They concede that we are entitled to solicit offers, Your Honor.
So as long as you can invite an offer, you can essentially have an option to purchase through the ROFR that will be below that which is set forth in Section 6.
Correct.
And why, I mean, that's an unusual, but that's dependent upon your view that the ROFR is different in years 1 through 15 versus years 16 and above.
I'm not sure I follow you, Your Honor. I'm not sure it is different. I think.
You just told me it was. You told me
Well,
in years
there
1 through
are-
15, you couldn't do it without the approval,
Okay,
the
but now
consent.
we are talking about year 16
Right, but
and
it
what's
doesn't, but the
happening.
ROFR provisions, the option to sale doesn't, the only times I see after 15 years being mentioned is with regard to the option to purchase. I don't see any reference to after 15 years being mentioned with regard to the ROFR.
I am losing track of your question, Your Honor.
The option to purchase kicks in only after 15 years, correct?
Correct.
Okay. Is there anywhere in the option agreement which says that anything else kicks in after 15 years? Because you're telling me that that part of the ROFR which allows you to exercise it without the consent of the limited partners kicks in after 15 years.
The ROFR kicks in year 1 through year 19, but Memorial Drive would be limited in allowing, issuing a disposition notice because of the specific provisions in the partnership agreement from year 1 through year 15 that protect the limited partners' rights to receive the tax credits. So it's a question of what can Memorial Drive do and when.
Okay, but I have to read those then into the option agreement, is what you're asking us to do, that if you read the partnership agreement, those provisions, they effectively say that the ROFR can kick in without the approval of the special limited partner only after 15 years. That's what you're asking us to do, aren't you?
I don't know, Your Honor, I'm not sure that's the way to look at it. I mean, these two agreements need to be interpreted together. And if there are provisions in the partnership agreement which controls Memorial Drive's actions, it's not going to be able to issue a disposition notice in year 1 through 15 because it's obligated under the provisions that protect the limited partners' rights to receive the tax credits. In year 15, those are irrelevant. They have received their tax credits. If an offer comes in, Memorial Drive is now no longer prevented from issuing a disposition notice.
The offer itself, it seems it's a fake offer. I mean, I understand all this may be necessary to comply with federal tax law, but it's not really an offer. This is all contorted from normal real estate law. This isn't really an offer and a right of first refusal in any traditional sense. It's basically a low-income housing tax credit offer, right? I mean, none of this. We got to ignore
It's
all
a different animal, Your Honor.
Yeah, it's a
It is
different-
not a common law ROFR. We agree with you there. It's not a common law ROFR Despite the limited partner's arguments that, common law concepts were incorporated here, the fact that it's a fixed price ROFR and that the holder can exercise it at a below market price changes everything.
Right, and just so I understand, so one of the amicuses, and there were 8 of them, so I can't keep track of them, but one of them said something to the effect of, you have these 2 different prices because basically the property may decline terribly in value
Correct.
because it's in a difficult neighborhood or something. So that's the explanation why you have these different price setups. They're arguing, he's shaking his head, and they're arguing that it's a sword shield analysis. Your argument is that it's 2 different ways of
Weapons on the
protecting your
battlefield, yeah.
client. Yeah.
Yes, it is. I mean, I don't think that the option should be interpreted.
And has
to-
any case said that anywhere? You would think some of this would have come up somewhere. But
It hasn't.
it hasn't. Okay.
It really hasn't.
And I appreciate your explanation that this is a different animal, and it certainly feels like it. But would you say that, and you've argued ably, the terms of this contract, that's what we should really just be looking at, the terms of the agreements that the parties reach, not this, how is it going to affect public policy in that lens? We're really looking at what did these sophisticated parties on both sides agree to?
I think that's the heart of it, Your Honor. I think the Superior Court considered some policy in terms of backdrop, which was important to understand what was happening here, why this is a different animal, what purpose it was designed to effectuate. But at heart, this is a contract dispute, and I believe that the contract provisions are in our favor. I'd like to point out 2 things, because I see the red light flashing.
Just one thing. You could be affirmed if we think the judge erred on the parole evidence, right? I mean,
Yes.
this memo, I have a little trouble understanding why that memo gets considered and not anything else. But you don't need that memo to be considered, do you?
We don't need the memo to be considered, but I don't think it was error that she did. And in terms of the argument that, well, the
Wasn't it
court
an-
only considered
I
our
thought it was
parole.
I thought it was an integrated contract, though, right?
It is an integrated contract,
And
but
was this integrated into the contract, that memo?
it was part of the closing binder,
Well,
and
but
it's not
that's-
inconsistent with the terms of the contract. That was what we presented to the court, and frankly, they didn't come up with any evidence to contradict it. And we only raised it because they had raised the issue of reasonable expectations. So there are just a couple points I'd like to finish on. One, if the special limited partner does have the right to veto any offer before Memorial Drive can issue the disposition notice, that will nullify the ROFR. They will never be able to exercise it. And that is completely inconsistent with what the option agreement says, that HRI has been granted the absolute right to acquire the property. And there's no way that that right could be absolute if it's conditioned on SLP consent prior to the disposition notice. With respect to the offer,
And they would never consent because the price would be too low? Is
Yeah.
that? Yeah.
yeah. And it puts the power in their hands, which completely undermines the idea of an absolute right.
But I don't understand if that's what was meant, then why don't you say you have an option to purchase after 15 years at any of the 3 prices?
I think they were
Why,
concerned
why
about
do
the.
it, why do it through this ROFR?
Because Section 42 says a right of first refusal. So the idea was to mirror the language in the statute and create a right of first refusal. But I think
Isn't it also because you got another tax problem, right? If you didn't do this as a right of first refusal.
A perceived
And you had
tax
an
problem.
option to buy, then without a condition, you'd be violating the tax ownership.
that was the
provision.
perception.
Right,
That was
that-
the concern. But there's nothing in Section 42 that talks about how the ROFR may be exercised or triggered. It leaves it to the parties. With respect to the offer and whether it's bona fide or not, if you require, it brings into question what does bona fide even mean in this context, because anyone who is going to buy this property is going to know about the right of first refusal. They are going to know that the holder is going to be able to underbid them. What incentive does anyone have to make an offer on this property just out of the blue, sua sponte? I mean, it's recorded, Anyone who knows anything about low-income housing tax credit projects is aware of it. Who's going to make an offer? So to characterize the offer as being not bona fide because Madison Park, figured that HRI was going to exercise its ROFR just completely undermines the whole scheme, and it would undermine, again, HRI's absolute right to acquire this property.
So help me to understand, I mean, what I'm essentially hearing is that the ROFR essentially is a dance around the tax law, that for whatever reason, if you were to give yourself an option, if you were to give an option to purchase at any of the three prices, that may provide a tax issue, and therefore to dance around the tax issue, you are trying to do the same thing through a ROFR. I mean, is that basically what you're saying?
What I'm saying is that the Section 42 requires a ROFR because there was a perceived, there was a perception that this would bump up against the idea of, certain tax principles. We still need an offer. We're not saying we don't need an offer. And it could be that an offer is not forthcoming. Someone has to do some work to make an offer, and maybe nobody would be willing to. But
isn't the chief right? You do have to, it is a dance with the tax law, but Congresses seem to have agreed to the dance.
If you look at footnote 344 of that joint tax committee report that is cited in our briefs, they basically say, where tax benefits are given and the purpose that Congress intended to effectuate is indeed effectuated, that we're not going to disallow those benefits.
Thank you.
Thank you, Your
We'll take our morning, nearly afternoon break.